So hello to everybody. Great to see that there's still some people showing up. I think it's one of the last sessions, but I think it's a pretty important one. It's the topic IPs and startup, I think, and every startup is focusing, challenging according IP, especially when they start. Unfortunately, one panelist is missing, but I think we will start not to lose too much time according to that. So maybe first of all, I want to introduce the panel. First of all, Michael Streich, he's founder and co-founder and partner at BambooVentures, a venture fund based in Munich and Vienna, and investing in technology-based startups and companies. Then we have Eva Prieschl-Grassauer. She's co-founder of a biotech company called Marinomed, and they're already down the road, so they have already some experiences with IP and everything about that. And then third we have Palmiro Torre, who is at the office of the Patent Office Austria. They're responsible for the IP topics. And my name is Stefan Kreppel, and I'm from the Research Promotion. And together with the Ministry of Traffic, Innovation and Technology, we are supporting startups on their way to solve their technology problems and come up with new innovations. And according to that, for us, it's also the IP topic is really important, and I think a big challenge also for startups in one way or the other. And I think it's a good start, maybe if you give us a short brief, nutshell, IP in a nutshell, what is IP and what is covered by IP when everybody's talking about IP, maybe.
Okay, so yes, with IP you can you can protect some things that you physically create. You have different types. We have different types of IP rights. The most important maybe is the patent. With the patent you can cover, you can protect invention in all the technical fields. Excluded from patenting are business methods, mathematical methods, discovery, and so on. We will see it deeper. Then you have trademarks. With trademark you can protect signs. I mean, the sign could be a word or a word with a picture. And you have the design. With design you can protect the form of a product or part of a product. I think we will also see that there are alternatives to these rights, copyright, trade secrecy, but I think we will discuss about them. Very shortly, the Patent Office is responsible for the filing and registering of patent, trademark, and design. But we are also here to give information in every stage of the creation of your idea through patenting and draft. Thank you. Sorry, I also will introduce my colleague Susanne Kerntaler. She's also from the Patent Office. She's a specialist in the field of trademarks. So if you have questions about trademark, we will be there, but at the FFG stand after this discussion.
They will stick to the booth of the FFG, so you can show up there and have some deeper discussions according patents, trademarks, and all these issues. But maybe let's dive into the discussion. So maybe based on an investor side, what are the topics according IP? Are they crucial for an investor to invest, or is it more or less a side effect, or depends, or what role do IPs play in that focus?
Well, primarily it is pretty positive if there can be some kind of IP protection. But according to my opinion, my experience, I think it pretty much depends on what you are doing. I mean, you stated it already. If it comes down to software and stuff like that, or digital things, it might be a little bit tricky to get some kind of IP protection. But on the other hand, I think what factor is way more crucial or more important than being able to register an IP, I think is the business model and speed. I mean, if legally, if you're entitled to, or if you have an IP protection, that's pretty good. But what do you do if, say, a multinational corporation breaches your IP? Well, of course you can sue them, no doubt about it. But normally, startups, they do run out of money quite easily. So It's a question of time and a question of, say, focus and the business model.
So according to biotech topic, maybe I think there's IP more or less the core part pretty often of the business model. So there you don't have the opportunity, not only it's the question of speed, but maybe it's also then the question of IP and technology, and to cover that then.
Yeah, and particularly in biotechnology, speed is anyway very low compared to other businesses. So there you really need to protect your IP, your inventions, basically not because you sue your competitors probably, but because no big company or pharmaceutical company will invest in your product, into the marketing of a product, if you have a competitor on the market very easily. There are different mechanisms how to protect a product besides patents, which is the crucial part. And our company says from ourselves, we have an asset-based business model, meaning that we create IP by doing our science and research, and then we try to create products out of this IP, or develop products out of this IP, make a real invention, and then partner this with pharmaceutical companies. And this latter step will not occur if you don't have protection. There is only one way out, and this is if you have clinical science and clinical studies, then you have a certain protection by the authorities, which depends on the market where you are working with. But this is much shorter. It's approximately 8 years compared to the 20 years you have with the patents. So, as I just mentioned before, speed is rather low in biotech. You also need to take care that you make your patent application as late as possible. On the other hand, you're forced by the investors or companies to make it as early as possible, so you are in a kind of caught in the middle situation. But I think the message would be as late as possible, to have as long as possible a patent protection.
So maybe according to the timing, when to patent or not to patent, especially when, how do you think when you're still in the development phase, especially then based on the patent office side, when you patent pretty early on and you haven't finished your invention or your R&D right now, then, and you came up with other inventions, what can be the critical parts then within the structure when you patent too early and then come up with further inventions then?
Yes, from the time, it's not so easy to say. Before, just add one point to the discussion. You have two situations in the IP rights. You have your own rights if you seek to achieve a patent or something similar. But on the other side, the competitors or others can have patent or other rights on products. So this could be a barrier to enter a new market. So you have to consider these two situations, not only the situation what you can do, but also what others have to impede from the time, the right time to apply a patent. You have to consider if you file a patent, after 18 months the patent will be published. And you have to disclose all your invention. This means that a person skilled in the art has to be able to reproduce exactly your invention. So you have to make the complete disclosure of your invention. And so you have to consider if you, in these 8 months, can have a competitive advantage and development age. Maybe you can use this 8 months to further improve your invention. You develop your invention, and you have this 8 months advantage over the competitor. On the other side, if you think that other competitors on your field can apply similar patents or very similar patents in a short time, maybe it's better to apply the patent earlier. So it's you have to check what the competitors do.
So on one hand, as you said, it's the topic not only to patent your own IPs, but also to see which IPs you probably would violate or which get into struggle on the other side. But especially throughout the reason that we have a lot of IP startups at this conference as well, and I think it's we have, at least in Austria and Europe, always the discussion when it comes to the stage that when I say I'm a software-based startup or I'm a software-based company, there are no opportunities to get a coverage via IP or to get a get something to protect them. So what's your opinion on that side, especially how broad is the opportunity there to get coverage via IP or not, especially on the one hand side, on the software side, maybe based also on the investor side, what are their interesting topics according these software structures and the questions there you maybe want to ask or want to get covered at least during your evaluation phase, and also from the patent side, what are the according topics there?
Me? Well, there's plenty of questions. Well, as I said previously, and I don't want to express it misleadingly, it is pretty crucial and good to have IP, definitely. I mean, talking about screw it, but it is, as I said, it comes, to me, the core point is being able to implement the whole strategy, and gladly you said it, in certain areas of business or industry segments, speed is necessarily, say, not as important as in other ones. But if we are checking, or if we're looking at specific startups, and as I said, we are in the high-tech, or you said it, we're in the high-tech field, definitely we need to check if we or the startup would violate others, definitely. I mean, if we run into a potential violation, that could cause a lot of trouble, definitely. And bottom line is, it will definitely decrease the speed of implementation. So definitely it is a very, from an investor's perspective, it is a very, very important part to look thoroughly, and yeah, that's it, basically.
So maybe from the patent office side, according to the softer topics, are there opportunities there to get coverage there as well, or how should these kind of inventions then look like to be at least have the potential to get a coverage via IP?
So, related to software patents, so software as such is not patentable. There are computer implemented inventions, but this means that you have you need a technicity. So you have you need technical features in your invention, not only software, or you have to solve a problem where the output is technical. So it's not so easy to protect software patents. In other countries like the USA, it will be easier, but also the USA, I think they will a little bit change the situation, because actually also business methods or mathematical methods could be easily applied in the USA. But also considering this point, it is important for startups. It's not important if you want to seek a patent. It's important to aware that patent exists or the right exists, and you have to check this situation. I think the best way could be that when you make your external analysis of the market, that you also check the rights of others. If there are patents, if there are trademarks or other types of rights, who can protect your product or similar products. A possibility could also be to check if others in your field use methods to apply or not patents, or if they use copyrights instead of patent. So a little bit check the competitors. So with patent monitoring, you can do this very easily.
Okay, so as you mentioned, not only the IP are not only the patents on the one hand, but all the trademarks. And I think all of the startups are coming with some new logos, with some new pictures, brands, icons, and especially there you also maybe could have some violations there. So what's your experiences maybe according to that when a startup already showed their trademarks or their brands without checking if they're covered or not, and then have to change pretty late then, or they have to rebrand then, maybe what their experience you had during that topics maybe?
Well, we didn't have this problem, to be quite open, so we were checking it beforehand. if the few trademarks we have, and it's just a limited number, I think we have 3. So trademarks is really a very small portion of our IP, but all of them were checked beforehand to avoid such a situation. But coming back to freedom to operate, I think this is key, obviously, the same as the patent itself, to avoid any violations. However, I think if you have a research of the patents, I think you quite easily can find out. You can ask a patent lawyer, for example, to conduct such a study, and then you can find out if you violate somebody else's IP. But this is definitely as crucial as the other side around.
Well, I think, as you mentioned, it is fairly easy to have these kind of preliminary checks before you start up a company. And at the very end of the day, it is an investor normally, well, we do that, is we do invest in a team and not primarily in a product or in a service. Definitely we do want to like the whole story, no doubt about that, but so if a team is not capable of doing these kind of easy preliminary checks, then how good is that team? I think that is a different perspective to the whole thing. I'm not saying that it's the most important thing, but it is a fairly huge stake at the whole decision-making process. And if a team comes up with oops, we did not or we didn't take a thorough look at these kind of issues, then we're not so pleased, and it's not a very good situation or setup.
I think this is a good point that you address when you choose the name of your company or of your product. You have to check if this thing is protected or not, because thereafter, if you go out of the company with this name and then you have to change it, could be a big problem. The same is in the field of patent. Some companies are not aware of the importance of patents, and we had a case in the patent office where a company diffused his invention, maybe to a small group of people, but then a newspaper published this invention with all the details, and so the invention was published to the public, and so it's not more possible to apply and to receive a patent, because the patent has to be new and inventive over the state of the art, and this is part of the state of the art. Another example could be today social networks are very important, and so sometimes people exchange idea over Facebook, and then you disclose your invention in details, and this would also be state of the art. Facebook disclosure of Facebook or other social network are state of the art and could be used to address the novelty and inventiveness of the patent. So to make this check before you start with your idea is very important.
Okay, so you say also the social networks have a really big impact already to the newness of your idea. So not to talk too much on the technical details at least, but according to the different ways of patenting, where you have national patents, then the PCT on the European or global level, or then also the differences approaches between the European patent law and the US patent law, with the difference of first patented or first to invent. So based on your experiences, what way is, on your opinion, maybe the best way to follow these legal steps, then to start national, then going over a PCT stage, and then maybe broaden that up, or going for an EU patent, or maybe skip and go over to the US and make an US patent first, and then skip over back to Europe. So what are your experiences based on that, maybe on the biotech topic, or companies you have screened or invested in, or also from the patents office side?
So when we started 10 years ago, it was very key that we had a patent application in both the US and the European Union at the same time, because at this point in time in the US the patent law was different as it is now, so you could even patent something in the US which was already applied for a patent in Europe, so there was a different situation which I think has changed now. So we had always the simultaneous applications with just some rare exemptions. Then we went for PCT and then for global rollout of the patents, and I think our biggest one has now 100 countries where the patent is granted, which I think this probably is also important from a startup point of view. Keep it short and simple if possible, so because you have to pay for all the translations later on. So don't invest into too much of an explanation if you can avoid it, and try to keep figures, for example, simple, that you don't need to translate all the figures into Chinese or whatever signs. This makes it very costly afterwards. So there are certain things one can take attention to avoid costs later on. And if you have a global rollout, it really affects the budget. So this is one thing, but we went with a typical thing like going PCT and then a national rollout.
From our perspective, I do agree, and I want to add one more thing besides the budget topic. It is definitely also about deploying resources. Normally, typical startups, they do not have a huge amount of personnel, which means that COO, CEO, CFO, whoever, they need to take a look at all these kind of things, or at least they need to drive it, and they need to liaise with their patent guys, lawyers, etc. And so that normally means that 1/3 or even more than that of the crucial team that was key for getting the investment by the investor, they are now basically tied up with these kind of legal things, and they simply do lack in day-to-day business. So this is kind of is a balance theme, and I would rather say that it is more important, as I said previously and a few times, to, if it's possible, to implement faster, and of course not to run into any problems due to missing research. But I think it's a budget. It's a balanced topic.
I think it depends a bit on the cycle of an invention. So if you are in the pharmaceutical world, the cycles are very long. So products are on the market which have been invented 50 years ago. Obviously, those are not protected anymore, but the cycles are very long compared to, for example, IT or to electronic. So I think the speed, the cycles, and all of this affects very much the strategy.
There are two possibilities to start national and then go international, or in the other direction. It's depends how also it's a question of costs. Normally the national invention is cheaper, and then you have 1 year time to apply the same patent in other countries or also international. So you have these 12 months time to make the final decision. On the other side, if you at the beginning check or you think that you want to apply the patent in a lot of countries because these countries are important for your business, then you can start international. The advantage of an international application is that you can apply, for example, it in English, and then you have 30 months time to decide in which country will follow the application. So you have 30 months time to decide the national phases, and so to pay the patent lawyers there and to make the translation. Maybe another method could be there are also countries like Austria which give the possibility to apply the utility models. The advantage of a utility model is that you receive the you have the registration in a very short time, so around 1 year, compared to the time for a patent, maybe 2 to 5 years. So also you have also to consider the life cycle of your product when you want to apply the patent. And please remember, the patent is not the goal of your. The goal is business, and so the patent has to be a mean to achieve to be successful in your business.
May I add one thing I just missed? Maybe suggestion to how to prioritize what countries could be good to as a starter depends on, I think, its competitive analysis, basically. It depends on where are your main competitors, where could they come up sooner or later, and then maybe you can prioritize, because I think it's also pretty much key to the performance of a team and of a startup to know their competitors and where potential competitors they can pop up.
Yeah, it also depends on the market size of a certain country. So if you go to Malta, it might be nice, but a few 100,000 people, if there are so many, probably is not the market size where it's worthwhile to apply for a patent. So all these small countries usually are not really followed.
You mentioned the translation costs, especially also in the Chinese and Asian markets as well. And there's always a discussion, does it really make sense to patent in that areas? Do you then have the legal basis then to force my rights there, or to get my rights there at least? And the point I hear then it's much more not important to cover markets where maybe the products will be produced, but it's more than the topics to cover the markets where you want to sell them, because if the competitor can produce them but not sell them, it's not that difficult. So is it more important, sort of based on the question, to cover the markets you want to be in, or the markets you want to produce in, according to that?
For us, it's both, because you get money for both usually. So if you produce, you get money. So and if you infringe a patent, you also infringe it if you produce. It doesn't matter if you don't sell it. For example, if you have a production site in Italy and the product is sold in Saudi Arabia, let's put it in just a constructed way, and you have patent production in Italy but not in Saudi Arabia, you still can sue the company for production in Italy because they gain the money there. So for us, it's both. Coming back to China, I think, and for me, and probably, I don't know if this is correct, but for me it reminds me to Japan 30 years ago. So when I was a small child, everybody was saying Japanese are copying everything without paying attention to patents. This changed as soon as they had their own patents, which they needed to protect, and the same is now true for me at least, and for our business in China. So as soon as they have their own patents they need to protect because of their inventions, they sooner or later start to also take care about foreign patents. And in case of a biotech company, it's not the case usually that you as a small biotech who had made the invention is suing, as I just mentioned before, anybody, but you have a strong partner usually then in the region who is capable of doing so. So if you have a large pharmaceutical company who has a license for your product, they have to take care about that. So this is a very different situation to probably IT or electronics, where you have a completely different setup. But for us, it's important to go to China. We have just one country where we, in particular, have a different situation. This is India. And we were told by many people, keep away of India because they don't pay attention to anything. In particular, second medical use patents, which means something which is already known but has a new application. This is not granted in India anymore. And so India is a special topic. But China obviously has changed a lot, and the first foreign patents are now taken to court and they are getting their rights. So I think this has changed.
So maybe one last question from my side, and then maybe I want to open the discussion also to the audience. But as you mentioned already, the patent research, especially in the beginning, not to violate other legal other IPs. Is there also these research or these IP researchers not only also sourced for competitor analysis, at least who companies could be based on their technology issues they are covering with their IPs, could be in your potential future market then, so that it's also not only a coverage or a look of not to violate somebody else, but also to get a better insight who could be maybe my future competitors or my upcoming competitors according to that.
Or partner, because you probably are in the same region of the technology, so it can be a future partner, and you can get lots out of patent which is not published, but which published in normal scientific publications, but which is only published in patents. So if you are looking for certain compositions, for certain formulations, you will not find this in publications, but you find it in patents. So patents are a rich source of information which is very often not used, and which is a pity in the end.
It's not only for partnering up, it's also maybe an exit channel. Because if you think of like the big corporations, sometimes they cannot basically claim or cover all with their internal R&D, so they're pretty keen basically on external R&D. And business models, if they can see that it works as well, or that it suits some kind of specific purpose, then it could also be quite a good idea to approach them if you want to sell.
Okay, so I've seen there's also already one question at the back. I think you will get a mic.
Oh, thanks. Thanks. My question is, you said earlier with the PCT patent, you have 30 months instead of a year to submit the patent in the countries. Like, would you say that it's an additional risk because you get to know later if your patent is actually granted because of those 30 months compared to a year? And if you would say that is a risk, how could you mitigate the risk?
No,
do you know what I mean?
I think it's not a problem of a risk because any patent that you apply, international or national, you have 1 year time to apply it with the same disclosure in another country. The difference is if you use a national patent first, then you have to apply in another country, in another language, the same patent within this year. Thereafter, it's not more possible. If you start an international application, the national phase, the time when you decide to go in several countries or not, is after 30 months. So you have more time. The difference is you have to pay more fees for an international application. For example, compared to an Austrian application, I think the international fees for the without translation and patent lawyer costs are about 3,000 euro. In Austria, you can apply a patent with 550 euro. And so this is so if you want to apply file a patent in 3 or 4 countries, basically to start with a national phase, for example. But you have to evaluate this point. But in any case, after 18 months, the patent is published and you don't lose the priority. So from this point of view, it's no risk. It's a question of strategy and costs.
Please correct me if I'm wrong, but the priority is always based on the date of application.
Yes, of the first application.
Yeah. So it doesn't matter if it's published earlier or later or whatever, yes. So it's always based on the date of application.
But I mean, the whole process at the patent office for a national patent starts after a year.
Yeah.
If I hand it in and internationally, I can take 2.5 years. Like, I would always wait because it costs, I would wait 2.5 years.
No, but you're protected from the very beginning on already. If you have an application, you're protected. You don't need it granted.
But the patent is not granted, right?
Doesn't matter.
But you receive this date. The first application is your priority, and you cannot lose this priority. Independent if you apply another patent in another country within these 12 months. Also, the second patent, you can use the same priority also for the second patent in a different country or international. So your priority is always the same if the application is the same.
Okay, I don't want to take too much time here, but I think it's a little bit of misunderstanding. Maybe we can talk later.
Okay, we can talk later about that.
I think, if I'm right, but the misunderstanding comes from the point that the protection is not based on granting a patent.
Is it not?
Because no, it's the final stage.
But if
protection
my patent is not granted,
the protection starts at the very beginning.
Exactly.
With the application.
But if the patent office says your patent is not granted,
then you lose it.
Exactly. So then I have no protection.
Up to this moment, you are protected.
But if I have this information in 1 year, I can react to it. And if I have this information 2.5 years, it's later on in the process.
You can, for example, make a research beforehand.
Okay, so that would be a way to mitigate the risk.
That would be my way. I would do a research beforehand before I enter such a phase.
Yeah. Okay. Thanks.
Is there another question?
I talked to some guys regarding patents, and there are two group of people. One says patents are not worth that much because if you've got a patent, you have to protect it. It's another thing. If you find from a competitor a patent that is similar to your product, would you try to contact him? Would you try to form a similar patent? Or I heard about the possibility about making a patent that is that goes around it or something. So how to react if you find something similar, which is not the same, but which is in your field and which is quite similar to your product. So it's a same product category, but with another technology, for example.
If the technology is very different, normally they don't are in contact. But to be, for example, mechanical and electrical field, they are two different. If the solution is for two very different fields, normally they are not considered the same patents. But if you have a similar patent, I have not one answer to your question, but I can say you can stop your development. You can try to further develop the idea and apply another patent later. Maybe you can infringe also the first patent, but then you can contact your competitor to try to find an agreement with the license, because maybe you have then a further development and the competitor has the first patent on this point. Or you can try to find a different solution, so go around the patent but you need different technical features to solve the problem. If you use similar things to solve the problem, maybe it's not inventive, yes. Could be a problem. So it's a specific case. You have to check the specific situation from case to case. I don't know if you have...
I would say there are certain options. I completely agree with you. If it's very close, you either stop your contact the competitor to get the license if you need it. It depends very much how crucial this patent is, how deep it, how much it overlaps. If it's more or less the same, and if the other patent is still in place, which I would check as the first thing I would check, is it still valid? And if it's valid and if you need it, I rather would go the way of contacting those guys.
Can I just, this is also the point, because it's important before you start. You have the idea. When you have the idea, you can start to check, to make search on your own. In patent database, there are, from European Patent Office, there are free database where you can search. You can contact the patent office to get information, also how you can carry out the search. But we have sometimes cases where people invest 6 months, 1 year in an idea, then we find the same solution in 5 minutes, so it could be problematic.
You've got this 18 months where you don't know if the patent has been assigned or not. So I've got the situation that I was working 2 years on the product. There was no patent, and I talked to some lawyers, and he told me it's you shouldn't try to patent it because you can't. If you try to sue the competitors, you won't be. The patent is not worth to patent it. But now there's a competitor that has been granted a patent about this product category, the same product category. So the thing is, if it's only the product category that he patented, so is it also about technology, how technology is being put inside the product or something? So if it's only similar and not the same, would you say you can't patent a product category, or would you say if there's a patent for a product category, then you should try to talk to them?
This is a very specific case. If it is obvious for a person skilled in the art, then it's not inventive, and you have no possibility to patent it. So it's that your invention is only new is not enough. You have to. It's also between inventions, so not obvious for a person skilled in that. And we can maybe discuss later. I will also be understand, because I think it's a specific case. It's not possible to answer this without.
I'd like to add something as well, if I may. Okay. I think you should also take a look at the metrics, the business model around it. How does your business model, your assumptions, etc., how do they change after this? If this is a real killer of your whole business model, definitely you should talk to these guys. Maybe you can offer something else, maybe sales, marketing, or some specifics that they don't have, so you're kind of a match.
Okay, I have two questions. First question, what's your take on talking to patent trolls, for instance, like a small startup? You just on the race to deliver your product to the markets, and then somebody comes with a bunch of papers without the product. So how to basically deal with this situation? It's the first question. And second is trademarks. How is it important for technological startups, like, I have an app, to protect the brand, the name? Is visual important at all or not at all? Thank you.
Again, depends on the field, I guess. For example, in the pharmaceutical world, to stress this again, usually the startups are not those who bring the products to the market, so the brands don't come from the startup. So in our case, trademarks, as I mentioned, are rather rare. So it's the company name and it's 2 platforms that we have, but that's it, more or less. If you really have something which you sell, then you probably have much a different situation because of the branding. So this depends on the field.
Yes, I agree with the trademark. I think if you, for example, if you don't want to exclude order from patentation, or if you want to look if they infringe your product, and you have, and your main point is the quality of your product, you can, for example, with a brand, you can improve your quality and say, I am better than others. So you very fast receive a protection of your brand, and for a patent you need maybe 2, 3, 4, 5 years to receive a protection. And in respect of the troll, yes, unfortunately there are some, this kind of patents, because there are companies or peoples which apply patents but they don't produce anything. So they wait that others make similar things, and they are. So as I said before, the best solution is to check before if there are patents, similar patents in your field, other solution, and then try to find information about this company, who they are, and so if they have other patents, if this is an industry, or, and so you can see, you can evaluate the risk that you have. We have some cases in where a software company was to take action because of one of this kind of patent, and maybe they had to pay some $100,000 to receive the license, because if you so it's very costly. So infringement and validity litigation are very costly. So
especially when you start with spending a lot of money into marketing and brand building, at least before that you should have checked if your trademarks are free, or if you have the freedom to operate according to trademarks as well. So I think this is one big issue there as well. Maybe one last question?
Yeah.
Oh, well then too.
So it's about the prior art that you talked about before. I was wondering, where would you draw the line of how much you can disclose about or tell about a product or software, whatever, before the application and after you filed the application? Because, essentially all startups, they talk about the products at one point or another, some more, some less. But I think if you can give some practical advice about what's okay and what's not okay, depending on the stage we're talking about, so that could maybe be useful.
So I think basically is the best way is to not talk about these things with people in general. You can make some confidential agreement with other companies, so then there's also a legal protection, so they cannot tell about these topics to other person. Yes, if you tell them what your product is or what you want to solve, maybe it's okay, but you please don't tell how do you solve the problem with which technique, because then I, as examiner, if I find some information also in the internet, this will be state of the art. So.
What information in the internet is okay? I mean, everybody posts something in Facebook, on a website, so if it's a product picture, for example, it's okay, but if it's like text and text specs, so it's not. So
Pictures are also very dangerous because we have some also litigation case where patent lawyers present picture as state of the art, and then maybe there are a witness who talks exactly this system, make this, and then could be state of the art. So the best way is to wait to maybe if you have, because if you disclose your invention, maybe you have the solution, so please apply the patent. When you apply the patent, then you can disclose everything because you have the priority. This is the best way. And with other employees, cooperate, or other companies, please make a confidential agreement.
We have one over there.
It's kind of more generic question. I'm a mechatronics engineer, so world moves super fast, and I don't understand patents to some extent. So, for example, we're in the connected vehicle space. If I Google patents, I find a patent that says if a car or a bike or a motorcycle is connected to a server, then that is a patent. But if you look today, this is just so generic. There is a million ways how to connect them and a million ways how to do. So, for example, let's take a mobile phone. Somebody sometime, patented some technology of it, but now it's everywhere. So, how do you work in this space if somebody has taken a very generic patent? Like, do I have to pay to them? Because maybe they even haven't done much in that case. I mean,
It depends. There are a lot of patents in this field, but I think normally each patent should disclose a different solution or a different component of the whole system. And what also I said before, if you make an invention and you receive a patent granted, this does not mean that you do not infringe other patents. It's possible if you use the same system. For example, if you use a mobile phone and there is a patent on the mobile phone and you just make an implementation on the mobile phone, you infringe the mobile phone. Then you have another patent with a further development, and you can exclude that to make your further to sell or produce your further development. But the original patent, if you use the same technical feature, you infringe this. So for this question, look for specific solution in this case. It's not a general solution. So the connection, how it is connected, could be a good way.
Unfortunately, the time is up, but I think the experts will be at the FFG booth and the main hall. So I think there will be still time for further discussions and some detailed discussion maybe on specific topics. I want to thank you for your interests and for the interesting discussion, and also the panelists for that really interesting insight. I think 3 or 4 things I wanted to highlight was not to patent too early, so that you don't hinder your innovations. Then preliminary check based on your competitor search, maybe partner search, and also not to violate somebody else's innovations or patents with your invention. So thank you very much and enjoy the festival.
Thank you.